Hi, Jennifer Kupiszewski here. We're going to be talking about the basics of adult conservatorship today. I want to give people a little bit of time to log in and get going. So I'll start by just telling you a little bit about myself. My partner, Emily Kyle, and I have a small boutique firm practicing in the area of elder law that we have here in Scottsdale. We do a lot of guardianships and conservatorships, and we really enjoy working with folks to help solve those problems. So we've had a lot of experience. We've seen a lot of different things that happen. And today I'm going to talk about the basics after you get appointed. My prior webinar, part one, a couple of weeks ago, I talked about how to get appointed, what was entailed in that process. And it is admittedly a pretty lengthy and difficult process. Today, we're going to talk about what happens next, what you should look out for, helpful for basically everyone who is going to serve in this role. Okay, so I'm ready to get started if you are. Let me pull up my PowerPoint here. All right. Okay, the basics of conservatorship. So part two, we're going to get going on this. Oh, there we go. There's the share screen. All right, so you thought getting appointed was difficult, and it is, and it's time consuming and it's hard, but then you are appointed. And so then what's going to happen next? And that's what we're going to talk about today. And there are so many things that are going to happen next. You're going to need to have your letters issued. You're going to need to go to the banks, credit reports, budgets, inventory, and so many things you didn't even see coming as you interact with various institutions trying to move this forward for the person that you care about and that you've offered to serve for. And it's a big responsibility. And I know that everybody I work with really wants to do it correctly. They want to do the right thing because they're trying to help someone that they care about. All right, so the list of conservator authorities actually in little teeny tiny print in the book that I have with all the statute takes up almost three entire pages. It is a lot. It's pretty much anything you can imagine that you need to do to manage the assets of a person, whether that be buying and selling real property or rental properties or operating that person's business or making decisions about renewal on life insurance policies, voting securities, voting as a shareholder, selling stock, selling other securities, paying taxes, both business and personal, if that applies, and even making distributions, things like making sure that if they have a child support obligation, that obligation has been met, or maybe they had an adult person they were supporting that needs to continue. It's what they would have wanted when the person had the capacity to manage their own finances. So you go to the hearing, you made it through that whole process we talked about last time. You testified, the judge said, yeah, I think that this person needs a conservator and you are the proper person to be that conservator. So then what happens? Well, before COVID-19, we would have gone down to the clerk's office and we would have been first of all, we would have been at a hearing together. Then my clients and I would have walked down to the clerk's office after the hearing, after the judge signed the orders and the clerk got them ready for certification. We would have walked down and gotten those issued. The judge just signing the order is not sufficient. You have to go down and sign the acceptance saying, yes, I'm willing to serve, because no one has to serve as a conservator, and get your letters issued by the clerk who puts together, hey, court appointed you, order, you've accepted, now you're the person, letters are issued, and that is what makes you the conservator. And it doesn't happen until then. In the time of COVID-19, the court has been using a GoToMeeting platform for everyone to log in, much like this. And we've been participating in these hearings virtually. Everything is still happening just like it did before the pandemic, people are still getting appointed. There is about a 24-hour delay, because now the way it works is the court will say, okay, by tomorrow morning, the letter or the orders will be in my outbox for you, whether maybe the conservator or your runner, in our case, somebody we pay in our firm, to go down, pick them up, walk them to the clerk's office, and have them issued. And so it adds about a day to the process. But other than that, everything's still happening as it should. I'm going to give my standard warning about these certified orders and letters that I always want people to know. They cost about $28 for each document to have the certification. The certification is the seal on the back page that says the whole document in its entirety has been verified by the court and is a legitimate document that people can rely on. And so you can't decertify the document, and the way to decertify the document is to take the staple out. So it's a very, very expensive staple. Don't take it out. That decertifies your document, because you could have put a page in between. I mean, we don't know what happened once the staple was removed. So don't remove the staple, pick it old school, lay it flat on the glass. That's how you make your copies. We call these letters your walking around papers. That is what most institutions need when you want to make individual transactions. Those are not normally the orders and the acceptance and all those things. However, when you first go to open the accounts and to notify institutions of your appointment, they will want to see the orders, the letters, and the acceptance. They'll want to see that whole package. Later on, you can just use your letters moving forward to present to various institutions. If you are giving your orders and letters to anyone to make copies of, maybe they're going to look at your originals and then they're just going to take a copy for their file or scan it in, I would recommend that you bring copies with you and just say, hey, you can look at it and verify that it's accurate, but you can't take the staple out. It's just so common for people to take a document these days and take that staple out to feed it in and make copies and not be cognizant of the fact that they just wasted $28. Oh, so how many certified copies do you need? That's a question I get a lot, and I'm going to give a super lawyerly answer, and that is that it depends. It depends on how many financial institutions you're going to be working with. It depends on whether or not they're local. It depends on the relationship. So if the financial institution isn't local, you're in all likelihood going to be mailing in your orders and letters and acceptance, that package. And they're going to want to see the originals. They want to see that court certified copy the first time. And they're probably not going to mail them back to you. If you're dealing with government agencies, they often will mail them back to you. They don't want to keep and be responsible for your certified orders and letters. And so they will mail them back. And also institutions in which you have a relationship. So let's say it's, with a financial advisor, and the financial advisor knows the protected person. That's the person who's under conservatorship, who needed help managing their financial affairs. And maybe they knew the son or daughter who got appointed as conservator. Maybe they're even the people who that financial advisor reached out to say, hey, I think mom or dad has a problem. And often those individuals, they're, because of that relationship, can be easier to work with. They may not require an original. So obviously you're trying to reduce the number of certified copies that you need, because that can really, really start to add up at $28 a piece. And so you try to avoid giving away originals if you can, if they don't need it. Again, that goes back to if they're local, they might allow you to come in and present your original orders and letters. And then they just look at them, but they'll just keep your copies rather than having you submit to them original orders and letters. Normally, things like annuity companies and life insurance and those, other companies you need to deal with, you'll be mailing to them. And so you will need a certified order, letter, and acceptance to present to those institutions. So we usually just sort of look at what the person has, and then that's how we figure out how many certified orders and letters we're going to ask for. And then I usually just do +1, just the unknown, who knows, just in case, because the dog ate the certified orders and letters, who knows. And the reason we think that's important is that there's a period of time after the appointment in which the order is not, it takes time for the clerk to scan it in and for it to get posted to what we call the docket. And if it's not on docket, then you can't go down and get more certified orders and letters. And if you can't go get more certified orders and letters and you need one, you're gonna have to wait that couple of weeks for it to actually hit the docket so that you're able to get more certified orders and letters. All right. So you got appointed, and if any of you are conservators, you're right about now thinking, oh yeah, that sounds super easy, Jen. I'm just gonna go down to the bank and everything's gonna go smoothly. And the reality is it's probably not. We hear all the time, you know, that our client, they go down, they're interacting with the teller at the bank or, you know, someone else at an institution, and they get pushback. Often we'll hear that they want to see a power of attorney. A conservatorship is a court order, so it trumps any powers of attorney, and the person has been deemed not to have capacity, and so they can't execute a power of attorney at this point. Yet often banking institutions, because that's what they're used to seeing, those are the forms they have in their wheelhouse, is they will ask for a power of attorney. And sometimes it takes a letter explaining. Often you just want to get to that person's supervisor, or you want them to submit it to legal, so that they do have a legal department. All these financial institutions have some legal department that they're working with, and maybe that's who needs to take a look at it to say, no, this is something we need to honor. It's a court order. Sometimes we get pushback that they'll say, well, it doesn't say that you can close an account. Given the list of conservator authorities that are cited to, and that in that order are granted, because the statute is referenced and it says that the person has all of these authorities, all of those 3 tiny print authorities that are in the statute. And someone will say, well, you don't have the authority to close an account. It's confusing for people at the institutions, for sure. Sometimes we have to go back and modify our orders to say the banking institution wants to see X, and so we need to list that out. They very often want to see that their specific institution is referenced in their order, because otherwise you sort of a general order, blanket order, it's uncomfortable for them to rely on when making these sort of major transfers into a new account that may not be in their banking institution, that may not be who you've chosen to work with, or maybe the conservator is consolidating a bunch of accounts because it's cumbersome, you know, to have accounts at all these different places. Some institutions, so will say they don't restrict accounts. Now, restricted accounts are accounts that the conservator has authority over, but can't withdraw without a court order because it's not covered by their bond. And some institutions don't want the liability associated with restricted accounts. And so, you know, they may not be willing to do what the court order says, and then you'll have to address, you know, moving those funds. Some will require a hold harmless agreement to say, okay, we're going to do this. And those agreements all look different, but I've seen that as well. So there are a lot of stumbling blocks along the way. Titling of the accounts. So when a conservator is appointed, the accounts have to be retitled to reflect that conservator, to reflect that this person is the conservator and this account is for the benefit of, and that's the protected person, the person who needs a conservator. So those accounts that they had before won't remain in their current form. Each institution will open a new account and retitle it. Now, when it comes to things like life insurance and annuities, they may handle that differently because those are contract-based, but there will always be some kind of shift, forms that will need to be filled out, you know, information that will need to be exchanged and delineated so that it shows that this actually is under the control of the conservator. So you're the conservator. That means you sort of are two people. I sort of enjoy probate because it's sort of the only place where you can clone yourself, because you are potentially the son or daughter of the protected person, and you are the conservator, which is legally two different people. Now you're not two different people, but legally two different people with different roles and responsibilities in the protected person's life. So it becomes really important how you sign your name in these situations, because you don't want to take your fiduciary hat off. You don't want to do that. You want to stay in that role. So when you sign your name, you need to sign it as in the conservatorship of or for, and then the person's name, the protected person's name, in my case, innocent citizen, the probate number, and that notifies people that there's a case. There's a probate case out there. Also, you want to sign as your name and that you're signing as the conservator. So we always tell people this is exactly how you want to sign any documents. And then you go, well, why? Why all this cumbersome stuff? I mean, if I have a letter, it says I'm conservator, what's the bad thing that's going to happen if I don't do that? Well, there was a case, and so there is a bad thing. And the bad thing was that the person signed a sale contract for the purchase of a home. They were selling the protected person's home, and they signed the contract individually in certain places, and then as in their fiduciary role in other places. And so what happened is they got sued in their fiduciary role, and that got resolved, but then they got sued in their individual role. So they were able to be sued again because they had taken that hat off, and they were in two different roles. And so they could be sued again in that role in their individual capacity. And you don't want that. That's not great. So you gotta, if you're acting as conservator, you got enough on your plate. You don't need that. Okay, so you should definitely get the protected person's mail. The mail is very, very helpful. The mail will tell you potentially about life insurance contracts. There's no one database where you can say, how do I know if this person has a life insurance, and how do I find out if it's term or if it's whole life, or should I, how do I get a copy of the contract to determine if I should be maintaining this policy? And the answer a lot of times is the mail, is getting the person's mail. Now, a lot of things are paperless these days, obviously. And so you're gonna need to go through the person's accounts and look for those automatic payments, all of the, electronic transfers that are being made, and try to track down where those are going. And that is possible. It's a little bit like detective work to kind of look through and be like, okay, what's this, what's that? But you figure it out. But the mail is a great source of information. It can tell you a lot about what the person was doing in their finances. And if you're missing something, let's say you didn't know about a life insurance contract because maybe they hadn't paid on it in quite some time, usually you'll get they'll mail a final type notice to be sure that the person got it. Also, governments, all the government programs, Social Security, the A.R.S, they don't call people. They will do direct deposit, but they don't, and you can make payments online, but other than that, everything that happens, if you're delinquent, if they're expecting a payment, if there's a change to Social Security, whatever it is, all of that information is typically sent via snail mail from government agencies. So the mail is important there as well. So can you invest funds? Because if you're putting it into a savings account, it's probably not earning much interest, if any. And that's not a particularly prudent investment, but it depends on the amount the person has available. So, or what the investment type is. Sometimes you might need or want court approval or the person's court-appointed counsel's approval of a particular investment. You're always going to want to do it with either an investment advisor or in something that's just no risk, like short-term CDs. So you don't want to tie up funds that the person may need through an investment. So you have to look at the budget, see what the liquidity is in the person's portfolio and the protected person's portfolio. Does an investment make sense? What are the terms? How old is the person? Is it a short-term investment? Is it a long-term investment? Those are all the kinds of questions and things you need to be thinking about for whether or not you're going to make such an investment. But you can certainly have the authority, as I said, it says right in the statute, you're buying securities, selling securities. So definitely have the authority to do so. But the question is, does it make sense for the person? So the credit report, this actually gets to be a little bit tricky. The mail takes a long time. You have 90 days. It seems like a long time, but we have to, because we're not the person, have to send in that certified order and letter and the acceptance to the company, to the credit company, to say, hey, we need a credit report, even though we're not the person. We have the authority to get it. So sometimes if the conservator, the protected person, if the conservator can work with them, maybe they can log in and get it if they have their information, because as an individual, you can always get your own credit report. So sometimes it can go a little bit faster. So can you be paid for services? And the short answer is yes. And the longer answer is, but for what, right? The longer question, I should say. It has to be reasonable. The typical hourly rate right now, Maricopa County is about $25 an hour. And it's really the services as a conservator, things like opening accounts, which actually can take a long time, paying bills. So that hour that you sit down and you pay all of the person's bills. Checks are easier to track. Oftentimes we're still using checks with a conservator. If you're negotiating any kind of a lawsuit, keeping track of time. In order to get paid, you need to literally keep track of your time. So it needs to say how long in 6/10 of an hour, like a lawyer bill. So 0.1 is 6 minutes, how long you did something, and then, and this is what we recommend, how long you did something and what you were doing, and then, you know, making sure that you're the one who did it, not someone that you hired. Because you can hire professionals and should hire professionals, such as financial advisors and accountants, to assist you. If you are hiring a bookkeeper, you know, then the bookkeeper is compensated, not the conservator as well. So need to be wary of what you're actually billing for, but yes, you can be compensated. In order to be compensated, a conservator has to file a notice of basis of compensation. That puts court-appointed counsel and the court on notice as to how much money per hour they're going to be charging, if that might change over time. Also, very important to send that out to disclose to everybody, not to the court, because it will all go in the accounting in the end to the court, but having all of those timesheets kept clearly and well, so that they can be provided as supporting documentation. Also have to notify everyone and keep track within a 4-month period, because if you go 6 months and then you try to recreate your time, you may not, there's a rule related to time and disclosure of those invoices, and you may not be able to be paid. Went backwards, but we'll go forwards. So can you initiate or settle lawsuits? I hear that a lot. I would say most often as it relates to financial exploitation, quite often the underlying reason that the person needed a conservator had to do with their cognitive decline or maybe physical decline, and it's come to someone's attention that they have been the victim of some kind of financial exploitation. Someone's taking advantage of the situation. So from my perspective, the short answer is yes, you definitely can initiate or settle lawsuits. But as I say, the question really for me is, should you be doing that given the expense? You've got to weigh the risks and the benefits. What is the likelihood of success? What is the likelihood of recovery? What's the amount that's in question? Because if you're initiating a lawsuit, that costs thousands of dollars. It may not be prudent to do that if the amount in question is $2,500. There are things short of lawsuits you can do to recoup funds, maybe making a demand, sending a letter with what you think has happened, maybe asking Adult Protective Services to investigate. So there are other things that you can't do short of a lawsuit. If a lawsuit makes sense, or if you sent a demand letter and you're going to compromise the claim, that means you're going to settle it, okay? That's fundamentally. So you're going to settle the claim, and you think maybe the claim is worth X, but it's going to, say round numbers, $100,000, but it's going to cost, you think, $50,000 to litigate. Then if you're going to compromise the claim, you know, people don't settle for their best day in court. They usually, the reason the incentive to settle is for less, which means you're going to take less than you think your best day in court would be. That has to go to the court. Certainly court-appointed counsel needs to be notified, because the court needs to make sure, because it's a vulnerable adult we're talking about here, the court needs to make sure that this settlement is fair and reasonable. And this comes up all the time in the context of nursing home neglect. Maybe our person who we're a conservator for suffered from neglect and had a terrible bed sore, and we're compromising that claim with the company where they were placed, or maybe they were in a car accident or something like that. There's a lot of reasons why you would compromise or settle a claim, but that needs to go to the court, and the fees related to it need to be approved as fair and reasonable to the protected person as well as the compromise. So keep in mind, yes, you can, but you may need court approval. So inventory. Every case is probably going to require an inventory unless there are very, very few assets and you're just appointed as a limited conservator. This tells the court and court-appointed counsel and any other interested persons what it is that the conservator is actually managing. What is under their control? What do we think its value is? This is very helpful for later things that have to be done, such as a budget or an accounting. You need a starting place for how much is there so that you can do the accounting and figure out what the budget should be. What happens with later discovered assets? Well, you can amend your inventory. What if you discovered the value of an asset is vastly different? Again, you can amend your inventory, or maybe that's reflected in the accounting. If there are out-of-state assets, they may or may not be under the control of the conservator. So, but you may want to note those on your inventory so that everyone knows that those assets exist, particularly because they might play into the budget. Personal property, there does not need to be an itemized list of every piece of clothing the person has. You know, they have 7 shirts and 5 pairs of slacks and 2 skirts or whatever. That does not need to happen. We're talking about things that have a more significant value. It might be artwork, it might be jewelry, a coin collection, that kind of personal property. Maybe needs to be specifically listed because it's maybe in a safe deposit box that's under the conservator's control, and you know the court needs to know where it is, how it's being managed, and that it exists. We list vehicles, don't typically retitle them. Often the conservator ends up selling the vehicle because the person is not able to drive anymore. That's a more complicated question, how to handle vehicles in a conservatorship. Definitely need to list them on the inventory though, for purposes of this discussion. And I'll just side note, little tangent, they need to be insured, and you need to know who's driving them. Can't just have people driving vehicles that aren't insured that may create a liability for the conservator and for the protected person and for the conservator. Okay, tangent. I'm gonna get back to my slides. Warning about vehicles. So this is what the court's inventory, this is just one page, it's several pages long, but you can see it's a form, it's a fillable PDF. Fill it out, put in what all the accounts are, what the values are. If I showed you the next few pages, you would see it would ask about real property and then about the personal property. So these are all the court forms. They are available in every county. I think every county, certainly your larger counties, they're available online. You just go to the court's website and go to probate, conservator, and then these forms exist. If they're not available in your county, you certainly can get them by just look at Maricopa or Pinal or Pima County. You'll get a sense of what the forms look like. All right, budget and sustainability. So once we have now we have our inventory, and we've gotten the mail and the credit report, and we've got a good sense now of what this person has and what it's going to cost to provide for their needs, and hopefully in the same manner that they had before. And so then we need to know if it's sustainable. So that's where I think most people understand, what a budget is, right? You need a budget, like how much income do you have coming in, and what are your expenses? How much is left over each month, each year, and does that make any sense? Often we are acting for someone who has a fixed amount of assets because they're either older or they don't work anymore. They've suffered some kind of injury, or they had a developmental disability, and that's why they have a conservator. And so they're not out in the workforce anymore. So their income stream is often fixed. And so we need to look at, and their asset accumulation is generally also fixed. And so we need to look at, is this sustainable? We go to the Social Security actuarial life table, and I wish I put a picture of it up. You go down, it says, here's how old you are, and then whether you're male or female, and then you go across and it says, here's how many more years that person is likely to live. And then we budget a little bit beyond that, because of course that is just a guess. And so we also look at, what are this person's underlying health conditions, et cetera. But then that's how we figure out what the budget is. You do have to file that with the court. And if there's any significant change in the budget during the time you're the conservator, you need to update and amend the budget and let everyone know that there has been changes. Like maybe there was an annuity and it was a significant source of income, and now it's come to an end. And so the amount of income coming in has decreased. And so how are we going to adjust that budget to account for that? So is there a good way to provide the protected person spending money? And the answer is yeah, there is. And the answer is no, there isn't a good way in terms of cash and actual debit cards. So those are not good ways. The better way is something that's fully trackable, that you as the conservator can put controls on, limit the amount. And so you can see here, we use a product called TrueLink. There are other ones, I imagine. This is the one I'm familiar with. We don't get a kickback from TrueLink, and I'm not plugging the product. I'm suggesting this is a scheme that you can use, because you can get a login, you can load how much you need onto it, you can set the kind of controls like where purchases can be made or how much in a day. You can block, you can see it right here, you can block bars and liquor stores, things like that. You can say yes to allow like pharmacies, sure, they can go get their medication. You can allow things like, their particular hair salon as a vendor. So there are a lot of things you can do with a TrueLink card that you need to be able to track, because it's going to be part of the accounting, which I'll talk about here in a little bit. But debit cards, not great. They can be stolen. They're at a lot of risk because they don't have the same protections as credit cards. And so if you had a debit card and it got stolen, they might take all of the money out, and maybe you have difficulty getting it back. That's why it's not a great idea. Cash, difficult to track, difficult to establish what's going on. Asking the person who's protected to keep receipts is probably not a great plan. So something like this would work much better. All right, we're going to talk about the annual accounting. So this is the thing that strikes fear into the hearts of everyone when you go and you do the training on the accounting and you look at the accounting forms. They are daunting. They seem very, very confusing. Keep in mind, you're the conservator, so you can hire someone to help you, a bookkeeper, an accountant, to do the annual accounting. You don't need to do this yourself, but you are going to be the one who's gathering up all of the information. So throughout the year, you've got to keep all of your receipts. You need to download all of the bank and credit card statements, anything where that conservatorship money went and was used. And you're going to need all of the checks. It is true that as conservator, checks are just really easy to track, and so a lot of people do still use checks. And most importantly, you're going to want to get help with that. It does need to balance to the penny, and it is going to go to court-appointed counsel is going to review it. The court, and most importantly, it's going to go to the court accountant, and they're going to look through every single transaction, and they're going to line it up, and they're going to come back and they're going to ask questions if things don't make sense. If you didn't include a footnote as to that, oh, that was an error, that transfer in and transfer out, it went into the wrong account or whatever happened. So you want to provide all those explanations, because there might be some back and forth. They may come back and say you need to adjust your budget or you need to adjust your bond. They can ask questions about the accounting. The court can hold hearings on it if the accounting's really off. The court-appointed counsel can object to the accounting if they look at it and they think this thing doesn't balance at all, it doesn't make any sense. So it's really important that this is done well and correctly. Trying to do it inexpensively, if you don't know what you're doing, likely is just going to increase the fees because of all the then back-end court involvement that will happen. So again, just to give you a sample of what one of the pieces of the court accounting looks like, is this is their sample transaction log. Again, these forms online in most counties for you to go and take a look at so you know what you're getting into and can make a decision if you want to try to do the accounting yourself. But it's very much, it's bookkeeping, and so you have to categorize every transaction and have the backup documentation for what happened and why that transaction was necessary. So I just want to talk briefly about the requirements of A.R.S, which is Arizona Revised Statute 46456. This is not in the conservatorship portion of our statutes. And what I mean by that is our statutes come in these books. And so this title is about probate, Title 14. And Title 46 is about welfare. So you can think about them like the titles, different topics, they're different books. And in the welfare statute resides the Adult Protective Services statute. And we have across the nation, there's a federal law, and every state has enacting statutes to enact that federal law that protects vulnerable adults. This does not mean it just protects people who are incapacitated. It protects anyone, whether it's because of a car accident or dementia or a developmental disability, whatever the cause is. It protects any adult who, by virtue of their diminished capacity, not incapacity, but diminished capacity, is unable to protect themselves, some mental or physical condition that impairs their ability to protect themselves. Okay, if you are the conservator, you are the conservator of a vulnerable adult. There's been a court finding that the person has some diminished capacity, at least with regard to managing their day-to-day finances, and that their assets were risk of waste or dissipation if someone didn't step in and manage their assets for them. So this statute has two things that create a place where you might be liable, in other words, civilly or even criminally, if you misuse the vulnerable adult's funds. One, vulnerable adult, and two, are you in a position of trust and confidence? Well, as a conservator, you're definitely in a position of trust and confidence because you're managing the person's finances. And so the court has placed you in that position. So you have an obligation to use those funds solely for the vulnerable adult's benefit. And if you don't, I just want to highlight for you, there are criminal and potentially and civil liabilities, and the court, when you sign up to be a conservator, takes all of your vital information, so your height, your weight, all of those things, your social security number, and they do that because they can issue arrest warrants if it turns out that someone stole from the vulnerable adult. There are some exceptions to using the vulnerable adult's assets for someone else's benefit, maybe they had a plan of gifting that you need to continue because that was part of their estate plan. And as a conservator, you have the obligation to maintain their estate plan. Possibly you need to do some ALTEX planning. ALTEX stands for Arizona Long-Term Care Services. So maybe they need long-term care and they don't have enough money. And so you're going to have to spend their assets in some way so that then they can qualify. Or maybe there are people the vulnerable adult has to, and I say vulnerable adult now, I should say the protected person. That's who I'm referring to. Maybe the protected person has minor children that they need to be supporting. And so those obligations, because the conservator also has an obligation to make distributions from the protected person's estate in order to provide for the duties of support that they may have. So there are exceptions. Those are a little bit beyond the scope of today. And I don't want to tell you to just go do it because it's dangerous. And so this is something definitely has to be run past probably the court and court appointed, at least court appointed counsel, to make sure that using those funds in that manner is actually appropriate. And of course, if you have an attorney, please, please, please talk to your attorney. So this is what I get asked all the time. What happens if I mess up? This is such a big deal. And I'm not going to steal. I know people, I mean, you're doing this because you care about this person and you want what's best for them. So honest mistakes happen and we can fix those. If you made a gift and now you're just like, uh-oh, I should have run that past people, you can still do that. And we can still go back and make all that happen. The court understands, and so does court appointed counsel, honest mistakes. Oh, I deposited my funds into the account and now I need to take them out. Or, you know, I accidentally used this card and it only happened one time. And so now I need to know I need to do it differently. So we can fix that. The most important thing you can do as a conservator is to be transparent with the court and court appointed counsel and to really follow and pay attention to the court trainings, the order to conservator that you signed to get appointed, and to be really thoughtful and ask lots and lots of questions about what it means to be conservator and how to go about those transactions. And so I'm hoping that this was helpful for you. It's always fun for me to at least virtually be talking to people. I hope you'll join Emily Kyle for our next webinar and then me again on the 5th. I'm going to have Karen Barr here. Emily will be interviewing Lori Neeson, behavior and Alzheimer's. Very, very interesting topic. I'm sure we'll learn a lot. Karen Barr, amazing person. Looking forward to interviewing here and hearing about the founding and the running and of Raising Arizona Kids, which is an amazing Arizona resource. And now I am going to take a look and see if we had any questions for me. I know I covered a lot. Sometimes it's too fast for questions, and I understand that. If you have any, I don't see any right now. So if you have any, I'll give it a minute here. If you could just let me know. I'm happy to take any that you may have. I know it's a lot. Don't be afraid of being a conservator. That's definitely not the point of this webinar, to scare anybody off. It's a very, very valuable service. It's a much, much needed service. And for the most part, if you aren't stealing, then you're going to be fine and we're going to be able to work it out and, you know, just really appreciate your service. And I am not seeing any questions. And so I'm going to go ahead and sign off. Thank you all for being here. We look forward to seeing you again and have a great day.